Welcome everyone again to the philosophy class. Wait, start that again. Three, two, one. Welcome again everyone to the philosophy class. We are studying the philosophy of law with Dr. Craig Wright. We are currently on chapter 3 and 4 today. Over to you, Craig.
Okay, so we've covered a lot of different areas already. As you'll know, we've gone into some of the purpose behind why we have judicial systems the way they are. This won't apply everywhere, of course. We're going to, of course, be basing this on a Western focus. It's not Sharia law. It's not something like civil French jurisdictions, etc. But the basis of what I'm talking about is really the legal system built in common law, natural law, and how that actually applies. So we've covered a little bit on the role of judges. We've gone into judicial responsibilities in legal systems and common law systems. And we've gone into a little bit on the interpretation and application of law. So when we're talking about this, we're really finding out how the development of legal principles occur through a doctrine we discussed, a precedent called stare decisis. And it is important to ensure that fair and impartial judicial proceedings develop. And without this, we can't. So this means that there should be consistency. So one of the key focuses that we'll find, or foci of any of this, will be, is it consistent? And the way and the reason for that, of course, and the philosophy behind this is people can then do business and know what they would expect as an outcome. If they're going to do something wrong, they have a chance of being caught. If they're doing something right, then they know they should be in a certain position afterwards. Unfortunately, many of these issues have changed over time, and especially with Parliament adding regulations, things like bylaws that you were talking about before, it makes it more difficult. So we discussed in the past the mechanisms of judicial interpretation a little bit, which includes the doctrine of precedent, as I just mentioned, of stare decisis, but also ratio descendiendi. This is also really reading what is put into a previous case and then examining how judges use these doctrines to ensure consistency and predictability in legal outcomes. So there's also different interpretive methods. We touched on that briefly: textualism, positivism, contextualism. And on top of that, there are a variety of other interpretive methods, including some of the Marxist schools, etc. And these are used in judicial reasoning and decision-making to have people understand what law is about and why it exists. So judicial activism is something we then covered. This is really focusing on broad interpretations of legal texts and an expansive view of a judicial role, covering more than just the law as it was, but trying to determine what you think, say, society or a community wants. And that, of course, goes far beyond the general view of what a common law legal system should do, or Western legal system should do. Once you start doing that, and we see it throughout the world, following philosophers such as Rawls in the US from Princeton, Rawls had the idea of, trying to bring ethics and equity. And the problem, of course, with that is, how do you define it? Many of these things are really subjective. And I'm very objectivist in my views. That is very different these days to libertarian, unfortunately, but I believe that you can actually find and interpret meaning. And an objectivist view of this and legal policy would really go into something that is, incredibly easy to understand. It should be fixed and set. So judicial activism, of course, influences public policy, individual rights, and social issues. And the problem with it is that although you may find that it could be helpful in some instances, it also makes the sort of application of the law subjective. It comes down to which judge you get on the day. And of course, we've all seen movies and TV shows where that's made into a farce, where the hanging judge or the sort of lenient judge is sort of begged for because of how they interpret things. But the problem with all of this is once you do that, then it comes down to if someone can sway the system a little bit or luck, and that's not really how things should be. Then, to recap a little bit, we went on and we covered some of the areas by Montesquieu, separation of powers, and we looked at how the judiciary's role contrasts with that of the legislature and the executive. And the idea here was to rebuild some of the sort of strengths of the Roman, republic, not empire, because, at that stage it had all fallen apart once again, but something where power is balanced, where no one group has too much. And in this, what we try and avoid is judicial supremacy. So judicial supremacy, it has an impact on democratic legitimacy and accountability. If people aren't accountable, if their decisions aren't transparent, then of course, as a system, we change from being a Republican type system, a democratic system, into something else. We become more oligarchical, where a few appointees get to set rules. So the concept from Montesquieu on was about balancing the judicial interpretation of legislative authority, the executive and other powers, to maintain an interpretive role and really preserve the integrity of democratic governance. Just coughing, or are we trying to say something? No problem. So when we're looking at this, what we need to consider is how it all applies. What we want to try and capture is how the balance between each of these areas, should be applied. Hopefully, some of you at least have read a little bit about Montesquieu. Montesquieu was an interesting character, a French aristocrat, of course, but managed to balance many of the sort of, powers that he could abuse himself, and wrote a lot of what became encapsulated in the United States, actually. The US, all of the founding fathers, especially the ones in the Federalist side, extensively read Montesquieu. So Montesquieu's theory of separation of powers is incredibly relevant to our modern legal systems. In areas such as Britain, they have a unwritten constitution, and that makes it a bit more difficult to interpret, of course. If you've studied extensively constitutional law, then the first thing you're going to realize is just how difficult it is to actually pinpoint anything. While there are difficulties in American law, constitutional law in America can be interpreted different ways as well, especially because of judicial powers. Then it's a lot simpler and more understandable. And I'll even extend this to an analogy of the change from the Catholic to Protestant when Martin Luther started nailing things. And what I'm saying here is one of the first things that happened after Luther started Protestantism is moving away from, Latin or Greek Latin for most of the Catholic Church into English or German. Luther started writing Bibles in German. Others did them in other languages, and that allowed the process to be more democratic. It opened it up. And a written, simple constitution, of course, opens up things so that people can understand it. They may not always. There are debates, very, very heated debates at time in America, like what does a militia mean? The right to bear arms in America says is terribly vague in some areas. Sort of, if you think about the right to bear arms, it starts really talking about a militia and then sort of switches, and it doesn't go into detail. It leaves a lot of blanks, and that's how people twist things. And that's something we've got to make sure that when we have laws or powers or anything like that, they're very narrowly focused. And this is one of the problems that also come about in the creation of this. The modern system of how we have parliament means that there is a lot of horse trading, for a better word. And in making legislation, especially in places like America where people tack things on, you end up with laws that are nowhere near as clear as they start. So quite often people draft something that is really clear and they become less clear over time. And this really changes the balance of power between the judiciary and legislative process, because as soon as you become vague, you open things up to subjectivity. And the real relevance of Montesquieu to our system is that we need to understand how we actually create something that isn't going to be vague. So the areas to really understand on this, we start with the articulation of the separation of powers, dividing governmental power between legislative, executive, and judiciary. The reason for this is that all of them really are fighting to be more powerful. But if it's done correctly, any gain by one is offset by the other two. In some ways, this is analogous to Bitcoin, not the Marxist concept of every person having a node, but rather, if you have one large node, it's going to be offset by multiple smaller nodes. So even if there's only 3 nodes, which is getting a little bit sort of, not decentralized enough, then it's still going to really balance out. Because if you've got one with 40% of hash power and 2 with 30%, then you still have, it's unlikely that they will collude because, cartels don't work in reality. They only do in movies. And over time, the members of that cartel are going to screw each other. So they're going to still fight the large player. And that's what we have in Montesquieu's theory. So if the legislature becomes too powerful, the other branches of government start opposing it. And in what we're doing here is we create somewhere where the concentration of power, the safeguarding of liberty, accountability, and transparency is balanced by the other parties. That's why we need transparency as well. So transparency is important because when all of this is open and people can see what is happening, then you can actually have an informed populace. And unfortunately, none of this works without an informed populace. That's one of the problems that we have in our modern society. It doesn't mean that everyone needs to know every law that's being passed, every case that's being done, but we need a media that isn't just sensationalizing things for the sake of it. So to go back into this.
Would you agree, Craig, that one of the other problems that we have is that the laws that are being passed are actually too big? Like they're, 15,000 pages of who knows what, and where nobody is even allowed any time to actually read it before it's voted on. And I mean, if the legislators aren't informed about what they're voting on, how can the public be informed? Like, to me, that whole system it doesn't work.
Well, in part, that comes back to what I was talking about before. The complexity of a law often grows because of people adding riders that have nothing to do with the original intent. So rather than redrafting something, quite often people tack things on. And this over time makes more and more complex areas. Or like horse trading occurs, and what you end up with is if you put this little clause into this law, I'll vote for it. And it may have nothing to do with the original intent of the legislation, or add things that change some of the aspects of how it will be applied significantly. So, I mean, this is part of what opens up subjectivity and judicial analysis as well. So one of the problems, of course, is the judiciary have a role, as I've been saying, in interpreting and determining law. To analyze this in how they interpret law, they need to focus on how they apply and interpret statutes within the confines of legislative intent. But the larger and the more convoluted legislation becomes, the longer it has been drafted, the more riders are put on, the more sort of side parties that are trying to be placated, then the more difficult it is to be subjective, so remove subjectivity and remain objective. So the judiciary's role in determining laws, it gets extended, and judicial activism can come into play.
It becomes very difficult to interpret anything with straight intent, because it's just so convoluted to really interpret.
I agree. But this is also why people need to, well, have some involvement in politics. So it doesn't mean running for parliament or anything like this, but you should be able to talk to people in your constituency, know what's happening, bother your or local minister, that sort of stuff. I've done that many times. In England, I'm a member of the Conservative Party, and in Australia in the past, I was a member of the Liberal Party, which sort of shows my politics to an extent, although not fully, because
they're really conservative that much anymore. They're just...
No, I agree. I mean, but you choose the lesser evil, so to speak, and you choose where you might actually make a difference. And it allows you to interact and talk with people. Some of that's boring as batshit, but you still get to do it. So what that brings us down to is it becomes a delicate balance. So none of these groups should have too much power, but they should be balanced by the others, because you also don't want it so that the other groups are too powerful to stop anything themselves and to crush it. That happened many times throughout history. And while Rome was very successful for a large number of years, the growth and the changes led to a need to integrate, well, new forms of governance that never occurred. The same happened with England. So if we think about it for a moment, one of the arguments about not giving a vote to the American sort of colonies, the 13 colonies there, was really, well, we don't have a vote for Birmingham, so why would we give a vote for these guys over in America? But the truth of the matter is, maybe they should have looked at it a different way, and maybe there should have been a vote for people in Birmingham. Maybe you should have actually looked at how the constituency was run. And then that would have changed everything quite a lot. So if, for instance, the George and things hadn't decided, well, to go down a particular route, then you still would have had a different empire. And that collapse and the split and where England is now would have been very different. And realizing that centers change would have helped. The Roman situation was also the same. People talk about the collapse of Rome. I'm completing a dissertation if I ever get time to finish it and submit it. But one of the arguments I would say is that Rome didn't really collapse, not in the way that people say. People moved. The capital became Constantinople. So those people with power, sway, etc., moved. And we see that throughout history. I'll give you an example of somewhere in America. 30, 40 years ago, Detroit was a booming city. Now many parts of Detroit are a ghost town. They're decayed, they're falling apart, and there's not much industry there, and without significant change, it's not going to have significant anything. So we see this change, and we have to accept that we can't embrace the past and keep it. We have to acknowledge that things change. So England should have acknowledged that the nature of their empire was changing the nature of England, and the power structures would move. Rome should have done the same. And all of us need to think about that. And a huge part of this is education, why I harp on it so much. Education isn't technical training. Montesquieu and the readings of the Federalist Papers would be education. However, while legal training as professional, while mathematics are all essential technical skills, these are professional qualities that need to be learned, especially if you want to go into jobs in those areas. They're not the foundation of education, they're training. And that's something we need to go more into as well. So going back into this and covering the changes that can occur, then we need to start thinking about how we create a system that stops the conflicts between the judiciary and the legislature. And many potential conflicts will arise. So if we think about this and we have legislature creating large pieces of paper that no one's ever going to read, then we're going to end up with distrust. Sorry?
Could you stop them from doing that? Could you amend the Constitution to limit the number of laws and the size of the laws, and then incentivize them to keep the total number of words in the law below a limit, and say, if you actually reduce it, we'll pay you more money?
You could try, but the first part of all of this comes down to actually being engaged. And the first part of that is not thinking that your opinion won't matter. That, I mean, everyone wants to tell you that now, but the reality is actually the opposite. And by interacting with even local MPs, etc., then that's how you make these changes. Enough people do it and change occurs. So to make sure that the problems don't occur, we need to make it so that the legislation that, well, the people we vote for, that they create, is suitable. If it's too complex, if there are too many riders put on, then subjectivity will creep in. Judicial decisions will be perceived as encroaching on legislative authority because there won't be any other way of doing it. When 2 people, 3 people, 4 people start interpreting legislation differently, then a judge is going to do the same. So it's not blaming the judge, it's not blaming the system. It's we need to think about how we tailor the system to keep things understandable. We have technology now, which makes all of this far more open. Yet we don't put any of this back into what we educate people on. We have removed it from most school curricula. We haven't really gone into teaching this sort of thing in schools anymore. We talk about needing more computer training, more technical training, more job training. But if we don't have the right underlying foundation of education, then none of that's going to matter. So in looking at potential reforms, resolutions, etc., then constitutional reforms can occur. That would be more difficult in somewhere like England than it is America. But either way, it's going to be difficult for the simple fact that any constitutional change is always difficult. You have to get a large number of people to understand and agree. Next, the roles of checks and balances need to be, well, explained. So if people don't have an understanding, if they, well, don't know how it's going to work, then of course, well, they're not going to be acting on it correctly. And we need people to have a rational sort of understanding and be able to debate, which is one of the areas of why I've done this as well. So if we start thinking about it, the reality is there will always be disagreements because not because things aren't rational or two people can come up with the same numbers, but because of how you then sort of have underlying values. If I value something more than you, it's really a subjective thing. If I like particular types of artwork, I like particular types of entertainment, then the balance becomes ones that, well, work for me. So going back into this, we need to start thinking about how we minimize the way that we give, well, the political lawmaking capacity and power and the subjectivity of law by actually creating legal systems that are sound. This enables us to start creating a executive action, legislative action that really prevents the concentration of power and risk of arbitrariness. And, well, from there, we might even have a culture of accountability. One comment, of course, I would actually see, and I see a problem with, is there is a lack of accountability in many judicial systems. But that's not something I can actually tell you how to fix. In the Supreme Court, for instance, the way that people are voted into power, well, is rather arbitrary from a presidential election and things like this. And I can't tell you how it would necessarily work better. Maybe fixed terms, maybe not. Sometimes the best people stay for a short time. Sometimes people who are terrible stay for a long time. And if I could fix all that, I would, but it's not an area that I can. But we need to think about actually creating and fostering a culture of accountability. And again, that comes back to education. So Montesquieu's articulation of the separation of powers is really the cornerstone of our modern democratic theory. It, again, to emphasize this, embodies the principles of liberty, balance, and accountability. This tripartite division of governmental functions ensures that power is never monopolized. When it fails, what we see is analogous to many modern instances of government, but also many in the past. When Octavius, basically adoptive sort of nephew of Caesar, came in and seized power, then he became a dictator. May not have called himself that, but that's what it was. And the same thing happened when the fascist state rose in Italy, when the sort of authoritarian governments rose in China and then moved to Taipei and then became less and more, and etc. And the counter-revolution to that with Mao, when we see what happened in Germany. All of this is really because of transparency and accountability. And if we think it can't happen again, then of course we're wrong. So Montesquieu's theory, as I've been saying, really is that you prevent tyranny and protect liberty by dividing power. I'm going to keep harping on that one. Legislator makes laws, executive implements and enforces laws, and the judiciary is the interpreter and administrator of laws. But in this, the interpretation should be minimal. It should not be something that is wide. It should be objective rather than subjective. And in our modern legal systems, we see this implemented in the United States, through the Constitution, the Congress, the executive power of the president, the judicial power of the Supreme Court and the other federal courts, and the checks and balances attributed to them. The president can veto legislation. Congress can override a veto with a supermajority, and the Supreme Court can declare laws or executive actions unconstitutional. This structure, of course, means that no single branch dominates. On top of that, we saw in about 100 years ago, back with Roosevelt, that if the Supreme Court doesn't do things, they can still be threatened. But luckily, that doesn't happen terribly often. Conversely, we have the United Kingdom. The separation of powers is not rigidly defined, but it is present. The way that the Constitution of the UK works is very different to the US. It's not written. It is a number of documents that are interpreted, making it far more difficult for the common person to understand. The UK, of course, has a parliamentary system.
It's like 1,500 pages of stuff, as opposed to eight pages for America.
Well, the actual Australian Constitution is far simpler than that, but it's been extended with other material that is, tacked on like a rider in a way. So the interpretations, etc., change it. So you could argue that the American one is far larger, but because of judicial interpretation as well, but not to the same extent. So, as I was saying, UK parliamentary system, executive is the Prime Minister and Cabinet, which is drawn from the legislature, Parliament. It creates a close relationship between executive and legislative branches, which differs from the American system. So there is far less separation there. Australia is very similar as well, although there's some federalist ideas chucked in. And the judiciary is independent in the UK. The Constitutional Reform Act of 2005 strengthened judicial independence. It established the Supreme Court of the United Kingdom, which is separate from the House of Lords. Now, the distinction here, and I still falsely call it Privy Council and House of Lords and everything like that, but the Supreme Court was really developed a couple of decades ago as a way of adding independence, because the House of Lords still is a, executive and in some ways legislative body. So this separation really strengthens the way that the UK sort of creates law and manages it.
If
this
I may,
can be... Sorry?
I was just going to add that to what you're saying. Yeah, there's a lot of overlap between Parliament and the Cabinet with the legislative and executive bodies. And sometimes an observer might say they scratch each other's backs when creating laws and whatnot.
Yes, especially when there are limited powers. But in forming coalitions, then what you're doing is forming consensus. So anyone in Bitcoin world should understand this. Consensus isn't 100%. Consensus is basically getting something over the line. It's the 50%. Consensus in nodes doesn't mean that you have everyone agreeing. It doesn't mean that every node sort of is out there. It really comes down to being able to follow the rules, act within the constitution of the system, not break those rules, and then continue. So in Bitcoin, that would be follow the rules of the white paper and other such things. And as long as you do that, off you go. They're at the races.
Interrupt. Can I ask about the EU? I Brexited, whenever that was. Was it 10 years ago now? I voted to Brexit anyway. And the reason I did so was because I didn't like how the European Union, they let the European commissioners create the laws, the MEPs can amend the laws, and then treaties are passed. And all of the member states of the EU have to basically come to a consensus to overturn those treaties. And any country within the bloc can veto. So from my perspective, that seems like a very authoritarian way to create laws, and a very, makes it almost impossible to ever overturn them. What's your feelings about the EU?
Oh, yeah, I'm not very much a fan of bureaucratic government, and that's the way I saw it. I mean, I'll get into France and Germany and others and their legal systems in a moment, but to really say how this works, there are some positives that they did, but far more negatives, in my opinion. There's no accountability or transparency. While they might publish a lot of things on the website, the transparency aspect isn't there. And what I mean by that is that the law gets passed and then you read it.
Exactly.
It isn't
The
that you get
TTIP
to,
was,
yeah, this is what we've done, this is your own good.
yeah,
Whereas transparency should be right from the beginning. This is what we're proposing. This is why. This is how it will happen. And unfortunately, that's not what occurs. So, interestingly enough, because of treaties, the Court of Human Rights and other things in Europe remain a higher court in some instances, overriding the Supreme Court in England. Although that's still uncommon and rare, there are instances where through treaty, some of the sovereignty in these countries has been eroded. Some people will say that's good, others bad. I personally like having lots of small countries rather than a few large ones. I like the fact that there are many competing different jurisdictions, but that's me. And my reason for that is I like the sort of increase of freedom that brings. There's more uncertainty for some people, but I prefer the other. So that's my personal choice.
Okay.
And that brings us, of course, into the EU, which will start with France. France's Fifth Republic was established through a constitution of 1958. It has a separation of powers. President, executive branch have significant authority, but there is a bicameral parliament and independent judiciary. These are there to balance powers once again. The Constitutional Council, the Council Constitutionnel, reviews the constitutionality of legislation. These are designed then to ensure that anything that passes applies French, constitutional law. And in many ways, the French have implemented Montesquieu's sort of recommendations. Although I still don't like some of the way that judicial inquisitors work. I prefer the somewhat an adversarial system, but both have their pluses and minuses, to be honest. So finding something that's perfect means having lots of different systems rather than everyone copying, and learning from each other's mistakes. Germany comes under the Gundes. I'm not even going to pronounce that properly. I've never pronounced German well, but German's basic law is really reflects the separation of powers. Federal Parliament, the Bundestag, holds the legislative power. The federal president and chancellor hold executive power. The constitutional courts hold judicial power. So the Constitutional Court, again, plays a crucial role and helps maintain checks and balances, reviews constitutional sort of stature of law, and ensures that everyone's operating within the bounds. That can be compared to other nations within the EU, of course, but I'm not going to go into that now. That will take far too long. But we can also look at other areas, especially ones that have had a British influence. If we take India, although there are some changes recently, especially with new parliamentary forces, etc., the Indian constitution establishes separation of powers once again. the legislature, executive, and judiciary are separated. It's based really on a British system and implemented that way, but Parliament is responsible for making law. President and the Council of Ministers have an executive function and basically implement law. And the Supreme Court and other courts interpret the law. Judiciary in India has played a role actively in maintaining checks and balances, mainly through judicial review. And this helps, the law apply with the Constitution. So overall, we've seen the general way things have moved has been towards this sort of check and balance type system that Montesquieu and others brought in or described, which really goes back to Greece, Rome, etc. And some of the core values of, what people fight against in Western culture now. It is, undermined by many nations because if you have these constitutional checks, then it makes it more difficult to have power. And of course, powerful people will want more. So they will try and undermine this. So the philosophical idea here is that liberty is best protected when government power is divided and subject to checks and balances. That's not nothing. That's not anarchy. Unfortunately, we see, as Mises and Hayek both described, when we have anarchy, we have a vacuum. And nature and politics both act to destroy vacuums. They will fill them up as quickly as they can. And when you have an absence of power, someone will come in and take it within whatever constitutional limits they can abuse. In Germany, Hitler came in legitimately. He didn't come in because because he had a coup or anything like this. He came in using the power of the German chancellorship, etc. The same happened in Italy and many other nations. We see through time and time again that people abuse systems when we don't have checks and balances in place. And it is the separation of powers that fosters accountability and transparency in government. It's by dividing responsibilities and creating these mechanisms for oversight and control that democratic systems safeguard against corruption, arbitrariness, and excessive concentration of power. And this, again, comes back into the philosophy of law. It is the rule of law that we're aiming for, but not arbitrary law, transparent law that is created, through not only the will of the people living now, but those who will live and those who have. An example being, if someone creates a system, as the founding fathers in America did, then even though they may have passed centuries ago, then they still have some say in it. It makes it difficult to change and just override. So, to go back into this, the judiciary's role in interpreting versus determining law, with the considerations we've been going into, is that we have both a philosophical and practical consideration to look at. The nature of how this works is that subjectivity is never going to be transparent. We can't generally explain why we feel a certain way. And if it comes down to what a judge ate for breakfast or something like that there have been studies about this, then we have problems. We have to have different interpretive methods. We have to understand these. And I've mentioned already textualism, purposivism, contextualism. Then how we interpret the meaning of text matters. Do we take it to be what was, what we believe the legislator wanted, the actual meaning of the words, how we interpret those words? And if words aren't written very clearly, they can easily be twisted. One of the things to remember is words can be easily reanalyzed. So in determining law, judicial determination means that we have, laws that change. Judicial determination also arises where statutes are ambiguous, as I said, outdated, or even silent on specific issues. one of the strengths of the common law is it's very malleable. If done right, it's transparent. But many people will say, we need legislation because we don't have law. That's rarely the case. If we actually think about it, there will be case law that has principles that apply. One of my favorite judges of history is Lord Denning. Lord Denning was a wacky character at times, but he came up with a whole lot of really good analogies. And those analogies were based on existing law, etc. The one that I've mentioned many times is that of the telex machine and later fax, where he argued about, well, whether someone heard a message when negotiating a contract across a river, as a ferryman, for instance. You call out, you see what's happening, etc. And the same can apply into communications. If we're talking about TCP, if we're talking about internet communications, we can apply the same judicial reasoning. And it's that judicial reasoning that underlies what the law is. So many times we don't need new legislation. We don't need changes in things. We need people to understand and correctly put out the facts behind something. If we describe things wrong, if we put incorrect fact in, then quite often we end up with badly shaped and incorrect law. So societal needs will change and they will evolve, but they will do so based on whether we accurately apply this, whether we have covered subjectivity, and whether, well, we control the systems that we're talking about. So I'm going to leave this for you to go through and continue reading. I recommend, if you haven't read Montesquieu, he can be quite long-winded at times. I enjoy his writing, but not everyone does. But I recommend at least once in your life, read him. I've read him several times. Then try and think about how that might apply with different conflicts: judicial review, executive orders, legislative veto, budgetary control. So that's also something that you need to think about. So one example right now is, well, education in the United States is very heavily controlled by the federal government, even though it's not constitutionally theirs. But what they can do is they can sign up using Treasury to pay money. If you sign up and do X, I give you budget. If you don't, I don't. And technically, the states in America then choose. They decide. But monetary controls are a very powerful control. And things like this are what undermines and skews our system. So some of the resolutions I want you to think about: constitutional clarity, clarity of law, checks and balances, dialogue and negotiation, all should be open. Consensus building shouldn't be behind closed doors. Public accountability, judicial restraint and understanding what judges do, reporting on that. Legislative prudence, basically clear language and intent, reduce ambiguity and judicial interpretation and conflicts, minimize them, and executive moderation. So I'm going to leave you to think about all of that tonight and ask, first of all, any questions?
I have some questions, but I'm going to send them to you over message. This was really interesting. You said a lot of very interesting things. Yeah, which I think I'm going to need to re-listen to the video after it's edited and such. I said my key question that I wanted to ask is, there's things like you brought up and said how, some things need to stay separate and fix things and keep it separate. How does the average person go about trying to be a part of the solution?
As I've been saying, first of all, you need to be educated and know what's happening. That involves reading more than, well, just the trash that you see on social media, but actually trying to see what's happening in Parliament. Parliamentary websites may be boring, but they do publish what's happening. Try and stay up with international law. Try and understand more than just a sort of partisan view of what might be occurring in the media. And for instance, I read a variety of different newspapers and I cycle through them. I read other journals as well. I read The Atlantic, I read Wall Street Journal, I read The Times. And I don't sort of just focus on one that I prefer. I try and read The Guardian occasionally, etc., so that I have a wide view of what people think.
Ryan, sure. Do you think there's a role for AI in this? Because I think AI would be really great at summarizing new legislation to inform the public of the kind of key points that are about to be passed or how it's going to impact their lives.
Yes and no. As I've noted before, AI is a hammer. And how you use that hammer, you can use a hammer to put nails in and build a house for the poor. You can use a hammer to beat someone's skull in. And there's a big range of things in between that. So hammer can be good, hammer can be bad. It's neither. It is the person using it.
I think in this instance, it could be very, very good, actually, like it being impartial.
It's a shame that the system is so broken that you need to think.
You need it.
I have to come in with a hammer and bash the crap out of this to make it work.
I don't think it's very impartial, though. I mean, there are jobs which you can apply for, which you are the human behind the AI correcting things, and there's a bias there. There's a bias between these so-called AIs because there are humans behind it.
There can be, yes. So it really comes down to don't just trust everything you have. Try and balance things. Even if you're using a tool, there are multiple AIs. Use different ones and analyze what one tells you.
Aggregate.
Yeah. Takes time, but if you want to get AI to be a search engine, go out and get a different version of it. So Chat or OpenAI is coming out with a search AI. I'm sure Google will do the same.
Well, Perplexity give you access to all the models, all the AI models within Perplexity, and references everything for you. So that already exists. It's very good.
Good.
Archie, you got something to say?
All righty. I will let you all continue debating.
Archie's got
hand up.
Yeah, I just had kind of a random question and like the general purpose or the Second Amendment, the right to bear arms is always interesting to me. And since you brought up like the hammer, I think the purpose, I'll just get your opinion on it. The purpose, I think, is obviously arms, and there's a purpose to it. But as far as the rights for people, it seems to me maybe it would have been better, or even a general purpose would it be that people have the right to use any tool. So could one argue for AI, Bitcoin, the internet itself, the government can't take could you use the Second Amendment and to argue like, hey, the government can't control the internet because the people have that right to use that, as that's information as a tool or an arm to protect themselves.
Yes, but again, they've got to use it correctly. So to go back to your comment, the Bill of Rights comes up with a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Now, of course, the Supreme Court decision, such as District of Columbia versus Heller 2008, affirmed that this meant that it is independent of a service for militia, but is for traditional lawful purposes such as self-defense. But we need to try and start understanding what all that means. And information, well, if we overregulate, it becomes a problem. If we underregulate, it becomes a problem. I believe in free speech, but equally, free speech should be tempered by truth. For instance, I mean, that's why we have libel laws and other such things. You don't have the right just to impugn people for the sake of it. So all of that needs to be balanced. So once again, it comes down to balancing powers.
What do you think of the role of increasing the role of private judges and private courts? Would it this increasing competition, would it be a way to use the market as a way to have checks and balances, or not so much?
It can work in some instances. Arbitration, etc., has a place. The problem is you can't really arbitrate something when parties didn't negotiate up front. So if an event occurs outside of parties who negotiated, then it's really hard to bring arbitration in. I mean, you can try and negotiate and get someone to agree, but people are generally going to be difficult to, well, control in those sort of instances. So where people have already had some sort of agreement, it works very well. Where there's conflict, that's the difficulty.
Okay, with that, everyone, more questions. Let's let Craig say his goodbyes and depart, because we've kept him over an hour. Back to you, Craig.
No problem. I will catch you next time, and I hope you enjoy the reading. I'm continuing with putting all of this together, and one of the things I will be doing out of the whole philosophy course, which I'm getting close to doing, is actually trying to publish this into something that, well, becomes understandable. Ideally, I'd like to find a way of integrating some of the other works digitally, like Montesquieu, etc., so that we have everything in, well, one, well, rather than like a book where you have one book, but digitally link it all so everything's available, maybe on Kindle or something like that. But I'll let you know how that's going shortly.
Sounds great.
All right.
Excellent. Thank you.
Have a great evening, guys.